Hello everyone and welcome back to our channel. My name is Anda Malescu and I am the owner of Malescu Law, a law firm based in Miami, Florida. At Malescu Law, we specialize in serving Florida companies and foreign companies and investors in the area of business, corporate, and immigration law. If you need to contact us, you have our contact information in the video and below this video. Today we are going to speak about the various options available for investor visas in the United States. But before we do that, I want to clarify that there are two major categories of visas available for the United States. First, there is the non-immigrant visa category, which allows an individual to live and work and do business in the United States on a temporary basis. The second major category is the immigrant visas, which allow individuals to live, work, and do business in the United States on a permanent basis. The holders of immigrant visas are generally eligible to apply for U.S. citizenship once conditions are met. We will review the various types of investor visas for the United States in this video, but there will be other videos that will discuss each and one of them separately and in more detail. The first type of investor visa for the United States is the EB-5 Immigrant Investor Program. This is an immigrant visa that allows a foreign individual to live and work in the United States and obtain their green card in exchange for an investment of $900 million in a business enterprise in a rural or high unemployment area, or $1.8 million investment in a business enterprise located in an urban area. The investor can choose to make the investment directly into a new business, in which case they will own the company and they will have an active role in the management of the company. Or separately, they can choose to make the investment into a regional center, which is accredited by USCIS. And in that specific case, the investor would take a more passive role and will not be involved in a day-to-day management of the business. However, regardless of how the investor chooses to make the investment and where to put the money, the investment must result in the creation of at least 10 full-time jobs in the United States. Members of the investor's immediate family, the spouse and children under the age of 21, will also be eligible to obtain their green card at the same time as the investor. A second option for investor visas for the United States is the L1 Intra-Company Transferee for executives or managers. This is a non-immigrant visa that allows a non-US company to transfer an executive or manager to one of its offices in the United States. Alternatively, if the non-US company does not have an office in the United States, it can transfer one of its managers or executives to establish the office in the United States. The L1 visa is particularly suitable to those foreign investors that have well-established businesses in their home country and would like to expand their business operations to the United States, and they have also worked as an executive or manager in the non-US company for at least 1 year in the prior 3 years to the time of the application. Unlike the EB-5 Immigrant Investor Program, the L-1 visa does not require an initial substantial investment before the visa is approved. The visa is initially approved for 1 year, and after that it can also be renewed. The immediate family members of an L-1 visa holder, the spouse, is eligible to apply for work authorization, and the children under the age of 21 can attend public and private schools in the United States. A third option for the investor visas to the United States is the E2 Treaty Investor Visa. This is a non-immigrant visa that allows a foreign investor to come and live and do business in the United States in exchange for making a substantial investment in the U.S. business. Now, one of the most important aspects of the E2 Treaty Investor Visa is that this type of visa is only available to individuals who are citizens of certain countries with which the United States has a treaty. There's also the E2 visa and the E1 visa, and the treaty is established country by country, and you need to check if your country would qualify for the E2 Treaty Investor Visa. A second aspect of the E2 Investor Visa is that the investor must make a substantial investment into a U.S. business. This can be a new business, or it can also be a pre-existing business, and it can also be a franchise. The substantial investment requirement is subjective, meaning that it depends based on the type of the business the investor is trying to conduct in the United States, what is the amount that will make this business successful. In certain cases, $100,000 investment might be enough, or millions of dollars might be enough, or $50,000 might be enough. Depending on the treaty and the country of citizenship of the investor, the E2 visa can be granted from a couple of months to a maximum of 5 years, the initial term of the E2 visa. After that, the E2 visa can also be renewed. The spouse of an E2 Treaty Investor Visa holder is eligible for work authorization, and the children under the age of 21 can attend public and private schools in the United States. Other options for the investor visas for the United States can also be the O1 and the EB1 for managers or executives or persons with extraordinary abilities. This is all for today. Thank you so much for watching. Please subscribe to our channel. If you need to contact us or you want us to speak about a specific topic, please send us an email at info@malesculaw.com or contact us by phone 786-410-6841. Thank you and see you soon. Bye.